upheld by a court, except in Wisconsin, and I suspect that will be overturned.
This idea of the poll tax argument is interesting to me because the case that they make is the first, as my understanding is the first Wisconsin case said that you couldn't require people to pay for that ID if you were going to make them have it. But then is what they've said and why they say it's unworkable is they say, hey, well, you have to show up with other documents that you would presumably have to pay for, your birth certificate, your marriage license, and things like that. And so they say that then becomes the de facto poll tax. So if you're responding to them and saying specifically how that's not, it doesn't seem like on its face to me a completely illogical argument to say in some ways these people are still paying to vote. Whether you agree with the conclusion or not, there's a little bit of a logical trail.
The problem is that the Supreme Court in 2008 by a 6-3 ruling said that that's actually not a problem.
Right.
Said that the state does have, in Indiana, it was Crawford v. Marion County was the case. It was a 6-3 decision. You had a liberal join with the conservatives of the court saying that the state has a very compelling interest in having people not cheat in elections. I always find this amazing, by the way, that usually the left starts with there's no voter fraud, and then you go, okay, I'll do a Google search, and you find all the cases of voter fraud across the country because there are some every year in every major election, and they say, oh, well, it's not enough for it to matter. And then you say, look at this Senate race in Minnesota, for example, counting down by hand to hundreds of votes. It does matter. It matters profoundly, and the Supreme Court's already said that ID is okay to have, but the Justice Department, because they're hyper-partisan and they don't care what the Supreme Court says when it doesn't agree with them, is trying to find any way they can to shift things around.
The important thing, though, is in this Madison ruling, as Ellison points out, is they did say, look, okay, yes, ID is required. The state has a compelling interest. As you pointed out, the Supreme Court says the state has a compelling interest. However, you do not want to disenfranchise those who are very, very, very poor or elderly and make it challenging for them to vote. So you remove all of the costs for them to be able to get the ID, and then you get to keep the voter ID law in place. That, to me, sounds like it's a good approach, and I think that's probably what's going to wind up getting
that's right. It's hard to make the case that free ID is somehow too much of a burden for somebody.
That needs to be the conservative argument, though, is that